Yes, this lecture is on foreclosure and contractual remedies for that, contractual options to avoid the hardships associated with foreclosure, and also bankruptcy. Um, First of all, there are two kinds of collections by foreclosure. There's foreclosure by sale, and then there's strict foreclosure. Foreclosure by sale, usually in those cases, proceeds are generated by judicial auction. So they auction, say, a car. A person has defaulted and not made his payments on his car, and so they'll put the car up for auction in a general sale. So it's not a very competitive thing. It's not likely to bring a better price, and a debtor would be well advised to try to avoid that situation if he can. That is, to redeem the property if he can, or find some buyer for it, or sometimes you can return it to a dealership and they'll take it and they'll sell it and maybe make a little more money for themselves and possibly for you, and save you some money, because you're going to be responsible for any deficiency in a foreclosure sale. So foreclosure by sale, usually the proceeds are generated by the judicial sale. The debtor, by return of the property, avoids repossession and its costs. So if you can return the property and they'll take the property in lieu of payment, you basically can then maybe avoid paying a deficiency judgment. So now the other kind of foreclosure, so what happens in a foreclosure sale, they sell it and they use the money, and that money is applied to the debts that's owed. And if there is a surplus, you get the surplus, and if there's not a surplus, if there's a deficiency, you have to pay the deficiency if all the debts weren't paid off. Also, remember that things like if they had to repossess the car, the collection cost of repossessing the car becomes part of what you must pay, which will come out of the proceeds. The cost of putting it up on auction, the auctioneer's charge, becomes part of your cost also. So it's usually better if you can actually get them to take the car, full satisfaction of the debt, than to wind up putting it up for auction. Okay, so the other foreclosure is strict foreclosure. A strict foreclosure, the creditor keeps possession of the collateral. That is, he retains possession of the collateral. There is no deficiency judgment then, because he didn't sell it, and he takes it in full satisfaction of debt. However, the debtor may want to block and force a sale, because if indeed the car is worth more than what is owed, not likely usually, not the usual case, you would get the surplus when it's been auctioned off, and therefore you would want to block it in that. So there are certain things, certain rules that apply, consumer protection laws that apply, that allow you to block foreclosure. Foreclosure by sale, notice the repossessing and selling creditor has to give notice of the time and place of sale to all debtors, including sureties who have signed up to pay the debt if the debtor didn't pay for it. So people who co-sign the notes get notice also of the sale. And any of those persons could step in and redeem the property. So there's certain rights of sureties that you would have that would allow you some advantage. You could redeem the property. If you see the price is going to go for a low price, you might yourself want to redeem it and then try to sell it on your own, or maybe use it if that's what you want. Or you redeem it and you give it back to the debtor, because the debtor is your son and he needs some transportation. He's got a job, a family maybe, and you want him to take care of it. Even though he's maybe financially irresponsible, you might just redeem it at that point. Probably you would have stepped in earlier if you knew what was going on, and so once you got notice, you might have stepped in and prevented the auction, because you want to avoid the cost of the auction, and you can redeem it before the auction too. And so the bank is interested primarily in just getting back the money that it has lent, plus the interest that has been earned. And any collection costs, and auction costs will also come in if those are required or spent. Debtor has a right of redemption, and sureties also. Creditor entitled to proceeds to the extent of unpaid principal, interest, and cost. So that's what it is. Unpaid principal, interest, and cost of the debt on the automobile, in this case. The creditor is entitled to the deficiency judgment if the debt of the creditor isn't wholly satisfied. They have a further charge against the debtor and can proceed against it with other means. They can garnish his wages. They can maybe take other property and sell that. But of course, it all has to be done by law. There are rules, federal laws, that restrict how much they can garnish in the wages of a person, and how that has to be done has to be very carefully done. And there are certain rules to how it's done. You can't just call up and tell anybody who answers the phone that you're garnishing his wages. So there's some privacy issues that are involved in garnishing wages. And there are limitations on how much you can take from each paycheck. So the debtor has to continue to live. So you can take something from each paycheck. In some cases you can't take anything from certain debtors don't make enough to actually be garnished. And in any case, you can also, if they have other property, you could also take that and sell that in satisfaction of the debt. And of course, their only resort would be maybe to file for a bankruptcy, which would be one way of legally avoiding it. And there are other ways. I mean, it's probably better if debtors in these situations would talk to the creditors and try to work something out. Many creditors are willing to work with the debtor, and it's in their interest to do so because it oftentimes is more for their benefit, and both sides therefore are better in working out it. But then again, nowadays I think a lot of banks are run strictly with certain rules, and things are just done by the numbers, and so they'll consequently be a little less willing to actually talk about how things could be worked out. So it kind of depends upon the bank in that sense. Okay, the debtor has a right of redemption. The creditor is entitled to proceeds to the extent of unpaid principal, interest, and costs. The creditor is entitled to deficiency judgment if their debt aren't wholly satisfied. The debtor is entitled to surplus proceeds, if any. We've mentioned all that. Sureties who paid can also claim some of that surplus. So if the surety has paid anything towards the debt on the car, if he made any payments, if he did anything that cost him, if he insured the vehicle, which would be oftentimes also a default. So there are other kinds of defaults that can apply rather than just simply cars have been auctioned off because the debtor didn't pay the insurance to keep the car insured. So the promissory note and the security agreement usually specify that the car has to be insured because the car is an asset out of which the bank can recoup the money that it had given to a debtor who's winding up not paying. So it's that security is something they have a right to, and so usually in those contractual documents there will be a requirement that the debtor keep it insured, and not to keep it insured is actually also a default. And surety should get notice of that too, and should be able to come in and pay that thing. So he may have paid some money, so he would have a right to claim those money out of the surplus, and so the debtor would maybe get all of the surplus even, but he could get some of the surplus if there's enough. Also, the debtor, the surety would be able to redeem the property, so if he wanted to, he could, like I said, take the car and do anything he wants with it. Strict foreclosure is different because with strict foreclosure there's no sale, and so there's no deficiency, but there's no surplus either. So consequently, as I said, the debtor might want to block foreclosure, strict foreclosure, and force a sale of that, which he can do. Creditor retains possession of the collateral, and he can do anything with it he likes. He can later sell it if he wants, and in that case there's no deficiencies, there's no surplus that he has to pay. But he wouldn't be doing that right away. Not permitted if the debtor has paid 60% of the debt of purchased goods. So there is you can't have a strict foreclosure where the debtor has paid substantially 60% of what the debt was or what the purchase price was. That would be blocking. That would be automatically blocking the strict foreclosure and taking the property in satisfaction of the debt. Okay. Notice of the intent to retain and the notice of the debtor's right to block strict foreclosure. So So the creditor has to send that notice to the debtor, and like I said, to any sureties who would also be considered debtors, because they remain liable for any unpaid amounts. Creditor can sell collateral after the foreclosure is final, but has no right to any deficiency if he's strictly foreclosing. Contractual alternatives, contractual options to foreclosure and bankruptcy. A composition of creditors. This is a contract where the creditors have gotten together and agreed amongst themselves, and usually the debtor signs on to this agreement also, and they agree to take less than full payment, less than full repayment of the debt owed, and they take this in full satisfaction of all their claims. So why would they do this? Well, they might do this because they think it's going to result in a quicker getting of money for them, and the results may be actually pretty much the same, because in bankruptcy oftentimes you're not going, if you force a person into bankruptcy, in an involuntary bankruptcy where the creditors or one of the creditor push him into bankruptcy, there may be cost to the bankruptcy, so there actually may be less to be recovered, and you have less, you don't even have hearings, you don't have as much paperwork, you just simply have to deal with other creditors, and they all have to come to agreement. So if they can't come to agreement, they're not going to be able to do a composition of creditors. The debtor might want to urge that. That's why you should talk to the creditors and see if you can work something out. So, but basically this is an agreement where the consideration for the creditors taking less than they're fully entitled to is each other's agreement that they will also take less. That's what happens if they go to bankruptcy, right? Because in bankruptcy you pay, the debtor has to pay only to the extent that he has assets, and whatever those assets bring that can be sold. And he has certain items that would be not subject to being sold, as we'll see when we talk about bankruptcy. There's certain exemptions, property that's exempt from property that can be reaffirmed, which is basically you're agreeing to pay some creditor his money, and the other creditors are not going to get anything. So for instance, in the case of a homeowner who owns a home, if in bankruptcy they take the home and they force it and they sell it in foreclosure, basically the proceeds pretty much will go on that sale to probably the bank that lent money on the house, because he'll have a mortgage on it. So he's got his mortgage and he'll get the money from that house, and there's probably not necessarily going to be anything left over for any of the other creditors. So if the debtor will agree to make payments, that's called reaffirming the debt. So he can apply for a reaffirmation of the debt, and it has to be something that he does. The court's not going to force that on him. The bank can't force him on it. He has to agree to pay the debt. If he has any income, he just can't. Maybe he has income, but he hasn't enough income to pay all the debts that are coming due, and so he's going to wind up maybe writing off some of these. Some of these creditors are going to be maybe writing off some part of their debts. Anyway, that's why I say the composition of creditors makes a lot of sense that way. And so basically, the debtor who reaffirms his home mortgage basically is going to pay off the entire mortgage over time, possibly with a different schedule, but a lot of times with the same schedule as it would have been. So he's paying the money on time, he's paying the interest just as he would. Maybe everything stays the same, and he gets to keep the house. So there are twin goals for bankruptcy, as we'll learn. One goal is to give a debtor a fresh start. And so this is consistent with that. He gets a fresh start. He's able to retain his house. His children are able to continue going to the same school that they've been going to. And he's able to continue his life pretty much as it was, except that he sheds a certain amount of his debt. And so he may lose some personal items that are not exempt from sale that he can't keep under the exemptions that are granted under the state, because the states are the ones who pretty much set the exemptions. In most states, it's the state exemptions that we're talking about. There are national exemptions, but those are not typically what you find being used because the states themselves can set up exemptions, and those are usually better than the national exemptions. And so composition of creditor makes a lot of sense when you look at it that way. So general assignment for benefit of creditors. General assignment for benefit of creditors, you set up a trustee. The debtor freely assigns his assets to a trustee who then has legal title to the properties that he puts up in trust to be held by this third party. And the trustee then usually converts the assets to cash. What's that mean? That means he usually sells them for what he can get. He auctions them off. Maybe he negotiates sales with them. It might be a better system in some ways than, say, leaving it to the bank, which is almost always going to auction off, and so they'll always go for an auction price, which would oftentimes be a lot less than that. But for that matter, a lot of things you might want to, like I said, a car, if you're defaulting on a car, it might make a lot of sense for you to just turn it over to the car dealership and work out an arrangement with them. And you know, you could even say, well, I expect if it goes for a higher price, you'll give me a surplus, and maybe he'll promise to do that. I don't know how you police that, but you could at least try that. Debtor freely assigns the assets to the trustee. The trustee, note, has legal title. That means he's able to sell it. You know, they could have made it so. I guess you could have it so that the assignment could have just given him a legal right to sell it as an agent, but it's typically set up that he gets legal title so he can sign for it and give documentation to the buyers without messing with the debtor. And so the trustee converts this to cash, sells it. He distributes the proceeds from those sales to the creditors and who sign the releases for the debtor. So the debtors are released from those creditors as they get paid. It's usually a better deal for them than the ones with bankruptcy. Types of bankruptcy. There are two types of bankruptcy basically that we're going to talk about here. We're not going to talk about bankruptcy for corporations or businesses. We're not going to talk about bankruptcies for farms. There was a farmer bankruptcy, but we're not going to talk about that. So we're not going to talk about Chapter 11. We're going to talk about Chapter 7, which is known as liquidation bankruptcy. And that's the one most people think of. That's where you actually wind up selling some of your assets. Typically not your house, like I said, that's oftentimes reaffirmed. Oftentimes not cars. A man and a wife, both of them might be able to keep one car of reasonable value. You know, and if somebody thinks it's unreasonable value. For instance, if you had an extremely valuable car like say a DeLorean, which is a collector's item, okay, and worth a lot of money, and you got another car that you usually drive, you would probably be able to keep one car. You might wish you could keep the DeLorean, but you can't keep the DeLorean because it has extreme value over and above. It's not a car that you're using for transportation. It's a car you're collecting for maybe nostalgia, maybe because you think it's going to be more valuable in the future. In any case, you're not able to keep that necessarily, and you may have to sell that. As a matter of fact, you might be able to avoid bankruptcy ahead of time if you sold that asset. So there's a story that was told to me by my bankruptcy professor back in college of Rosie Red. She's sometimes called Rosie Rose. Pete Rose's wife, which her first name was Rose, so Rosie Rose, and so she actually divorced Pete, and a very strange thing wound up. She wound up with possession, because the property is divided up by the by the divorce judge. She wound up with a possession of a uniform that had been owned and kept by Pete Rose. So that uniform was the uniform that he wore when he broke Ty Cobb's record. And that uniform, therefore, has, like the DeLorean, collector value. So people would love to have that uniform. So you could sell that. And when the bankruptcy lawyers came out to list her assets and evaluate what kind of property she had, they decided that she didn't need to file bankruptcy. All she needed to do was probably to sell this uniform, put it up at auction, and that she would probably generate enough money from the sale of that item to cover her debts and wouldn't have to go through bankruptcy. So I think that's what they did. Otherwise, it would have been otherwise liquidated in the process, and probably it would not have been as good for her. It's probably better, like I said, to work these things out without going to bankruptcy if you can. And so the the bankruptcy trustee, not the bankruptcy trustee, her bankruptcy lawyer was doing her a great service by recognizing that this was not just anything. And what it was is he sent a guy out there, and the guy goes through and is looking at things, says, and normally clothes don't carry very much value, you use clothes. But he notices that in the closet there is this red uniform. He says, "What's that?" And she tells him. And he says, "Well, that's got considerable value. We can't treat that like these other clothes. We've got to list this separately. And you might think about just selling it and getting for it." So anyway, so liquidation is what we normally think of as bankruptcy. It's also called straight bankruptcy. Most common kind of bankruptcy that's filed. Individual repayment plans or Chapter 13 are the other type of bankruptcy. They used to call these wage earner plans because the ideal is a person might have some income. Well, it may not be wages from a job. It's any kind of income. If he has a regular source of income, it could be Social Security benefits. Maybe he's been injured and he gets disability payments every month. As long as he's got some sort of income, he could maybe pay on an individual repayment plan. So let's say he had a settlement where he had been injured in a suit and is getting monthly payments from whoever. Or maybe let's say he's a son of a wealthy individual who left him a trust fund, and he gets payments that are regulated by the trust fund. How the trustee allowed this to happen, I don't know though. But anyway, it's any kind of repayment. It could be a woman who got a divorce but is collecting child payments and also alimony payments, and so those also could be treated as that. Social Security could be the source of fund. Obviously, retirement monies could also. So, a combination of the two might actually happen in some cases. So, individual repayment plans. What happens there is a little different than the straight bankruptcy. Instead of winding up selling your assets, what you're doing is you're paying out of this income that you've got, and you'll have to pay a certain amount. So the court will allow you to pay something, and maybe you'll wind up paying 40% of the debts that are owed out of income. There is, if you don't pay enough, the bankruptcy judge has discretion and can order you to come up with a different plan, or or force you into straight bankruptcy if you won't come up with a plan that he will approve. If he doesn't think you're paying enough, given your income and the amount of debt that you owe, he can basically force you to come up with a different plan. So you come up with a plan, you propose it to him, and the creditors can also be there at the hearing. They could object to the plan, and he himself will probably object to it if it seems to be unreasonable, if it seems that you could actually pay more, and he'll probably suggest that you resubmit the plan. In other words, he's telling you, I'm not going to approve of this plan, but you might want to resubmit it because I think that they can pay more. Now, you could come up with reasons. I mean, you could argue with the judge and come up with reasons why she can't pay more or he can't pay more, why this person can't pay more. Maybe he or she has some extraordinary expenses that justify that he's not considering. But these bankruptcy judges are pretty shrewd, and they usually, you should put all that into the plan in the first place. And so probably you need to think about that. If you were a person who filed that way, you and your lawyer need to think of replan the thing. Individuals with regular income. So that's what it says. It's individuals with regular income, we call that. That's Chapter 13. Okay, we're not going to talk about Chapter 11 or 12. I listed them here, but I'm not going to talk about them. Basically, they're restructuring of debt payment, much like the Chapter 13. So 11 and 12 are also a restructuring of payment with different kinds of provisions for farmers and for corporations and businesses. Purpose. The purpose of bankruptcy, I think I already told you, there are two purposes. One, to allow financially distressed debtor a fresh start. This is most famously stated by the 1978, which is, I think, the last major. There's been amendments to that, including a major amendment in 2005 or where they amended this, but to allow financially distressed debtor to have a fresh start is the idea. So everybody deserves a fresh start, right? He screwed up. He wasn't able to make his payments. He's gotten himself into financial difficulties, and so we'll set him up again. We'll let him start over and give him a fresh start. However, we want it also to be fair and equitable treatment of all the creditors. So this is the second purpose. Fair and equitable treatment means that some creditors are not going to be favored. So if a debtor has borrowed money from his uncle and realizes that if he goes to bankruptcy, probably his uncle won't get full payment. And so if you wanted to, let's say he decides he's going to pay his uncle before he files bankruptcy. There's a time period. If he pays him within 6 months of filing bankruptcy, the bankruptcy trustee, when he finds that out, is going to basically declare that a fraudulent transfer and require the uncle to return the funds, and that may actually even prevent the debtor from getting the bankruptcy or change the nature of the bankruptcy in some ways. So we'll talk about that later also. So fair and equitable treatment of all creditors. Obviously, if you're paying your uncle and other creditors are not getting their full payments, is that fair? Okay, you say, well, he's my uncle. I sympathize with you, but you can't make special payments to people. You can't pay one creditor. Everything has to go through the court. Any payments have to go through the courts. Now you make regular payments, like for instance, before you file bankruptcy. If each month you've been paying your gas and electric bill, the court's not going to say, well, that's wrong. Yeah, you pay them in full each month, but these are regular expenses. So gas and electric bills and water bills, those kinds of bills that are regular payments that you're going to make that are necessary to keep your lifestyle normal, those kind of normal ones. We're not talking about that. We're talking about if somebody's lent you money for a purchase of an asset, or somebody lent you money on a personal loan. Those can't be subject to favoritism. Okay, now for filing a bankruptcy, they have to be filed. The individuals themselves can file, or creditors can force them into bankruptcy. If the individuals themselves file, whether they file as a couple or if they file as individuals, it's called a voluntary petition. Voluntary plans may be filed, and although the debtor need not be insolvent, he just may be running into difficulties paying his debts, and in which case he'll probably wind up paying pretty much all of his debts, but there may be some rescheduling of when things become due. So anyway, married couples may file jointly. The court may dismiss a case or convert a filing. That is, if you filed it as a repayment plan, a Chapter 13 might be converted into a 7, or vice versa. The court may dismiss a case or convert a filing on either his own motion or on general grounds of abuse or on a motion of any interested party. So the court is going to look at things, and if it finds funny things like fraudulent transfers, it's going to maybe see that as evidence of abuse. If the debtor's income exceeds the state's median income, and he's filing bankruptcy, then any interested party may move to dismiss it for abuse. The ideal is that, well, if you're making the median income of the state, you probably are able to pay your debts. So there's a kind of presumption there that you are, abusing the bankruptcy system when you can actually pay. However, of course, there is this presumption, but that only that's a rebuttable presumption. So it leads to an abuse and means test. I'm not going to give you detail on how the means test is at a certain mathematical formula. If you get into bankruptcy, you can more deeply involve that. So anyway, requirements for finding of abuse by the debtor. So the means tests indicate abuse resulting in a rebuttable presumption of abuse. The presumption of abuse may be rebutted by proof of special circumstances. And so there could be special circumstances that are causing this individual to have expenses that are extraordinary and different than other people might have had. Something like, oh, I had when I just graduated from law school, one of my first clients was a man who had a wife who had been slowly dying of cancer. And he'd been paying the doctors what he could, but he wound up, at her death, he wound up with quite a bit of money he still owed the doctors. They were very sympathetic to him in his situation, and they were not pressing him for the money. But he thought he should, I told him, well, you can file bankruptcy and you could get it all behind you and get a fresh start. And, you know, he was making enough money, I think, that you might ordinarily think that he'd be able to pay all these debts, but not with this huge amount of money that he was owing on his wife's last expenses for her death, her treatments in the hospital. You know, they'd been married for 40 years, and, you know, very nice couple, and friends of my parents. They were neighbors of ours, and it was heartbreaking. And he was afraid he was going to lose his house. And I said, no, you'll be able to keep your house, that I'm sure of. And we'll reaffirm that if necessary, or we can, you know, get that. Well, that was back then. They toughened up the laws now, so there might now be a presumption created against him. He probably would have flunked the means test. He probably would have qualified under the formula to be able to pay his debts on time, except that there was these extraordinary expenses that were related to his wife's last illness, her cancer treatments, which were very expensive at that time. And she lingered on a long time. And so he was able to keep his house and pass it on to his two daughters. Yeah. So, general grounds. General grounds exist for, so there's these two requirements. The means test, that's the first thing that creates the presumption. Like I said, that can be rebutted by proof of special circumstances. And general grounds exist for the finding, if there is one, of bad faith. Now, I'll say this, that even before that Bankruptcy Reform Act, judges were on the lookout for abuses of the system and would sometimes challenge somebody's filing of a bankruptcy, saying, well, I think you should be able to pay this. I think what the 2005 Act did was to cause bankruptcy judges to have sort of maybe other people looking over their shoulder to see if they're following these rules. And I think they were always following rules like that to do it anyway. Anyway, fraudulent conveyances, concealment, and non-disclosure of assets, or all circumstances revealing abuse. Also, the thing about that particular Bankruptcy Abuse Act is what they called it, I think. It's consumer protection and bankruptcy abuse. I found it was more for protecting the banks from being abused than it was, I think, and other creditors from being abused than it was in terms of consumer protection. I don't see much in there that was really related to consumer protection. But that was at a time when people thought that too many people were avoiding paying by filing bankruptcy. And, you know, the thing about bankruptcy, once you actually get into the system and you meet people who are filing bankruptcy, you find that there are generally two types of people, two types of debtors who wound up going into bankruptcy. The vast majority of people are people who maybe have lost their job, and therefore the ordinary expenses that they had that were based upon their income, they were not able to keep up with, and eventually they wound up not being able to get another job that paid maybe enough to keep the assets that they had, and so they wind up in a bankruptcy to, you know, basically get them a fresh start. And the other type of people was like my friend, Mr. Buckley. He was left with this huge medical bill, and the doctors were very sympathetic, but of course they can't just dismiss these bills. A lot of it was owed to the hospital, and actually they have to make a living too, right? So they deserve to get paid. And they didn't have any resentment to his filing that bankruptcy. And so a lot of the people who file bankruptcy are that way. But there was the perception that the people were going out and gambling away their money and filing these bankruptcy. Yes, there were people like that, but I think these were not those. That was not the common person who filed the bankruptcy. And actually, judges were less sympathetic towards those people always. Anyway, general grounds exist for finding if there is bad faith. General grounds may exist. For example, fraudulent conveyances might indicate to a judge that this person is trying to, you know, slip a fast one. A fraudulent conveyance is, like I said, if you were giving, let's say you're going to file bankruptcy. But before you file bankruptcy, you give a car which you had purchased, 3 months ago, to your mother-in-law, okay, and you resell it to her at a very, very good price, okay, and eventually the judge looks at it and says, well, this is not a fair price. I think this is a fraudulent conveyance. He can avoid that transfer and reclaim that car, and he's going to maybe note that as indicating possible general grounds for believing that there's bad faith in this filing. Concealment. So some people will try to conceal assets that they have, and some people will actually try to transport assets to other states and other kinds of things. So there's various kinds of tricks that people try to get away with. And non-disclosure of assets. So these are the kinds of things that the judge will take very seriously if those are shown, and or all circumstances. But it says or all circumstances that reveal abuse. So there are maybe other circumstances that are maybe not quite as serious as the ones that which will be taken into account. Concealing assets and non-disclosure of assets, fraudulent conveyances. These are rather serious kinds of things, and they clearly would indicate an abusive debtor, maybe. Involuntary petition. Involuntary petition is what the creditors file, and it's forcing the debtor into bankruptcy. The creditors with sufficient unpaid debts. Now, it could be just one creditor, and he could have enough money owed to him that's not being paid, may file for the debtor, who can challenge the petition. The frivolous filings can result in penalties if the creditor needs to look and make sure that this person is not acting with sincerity, that he's acting frivolously, or that he's acting that he's not paying debts that he should be paying them. The court will only issue an order for relief if the creditors prove that either the debtor is generally not paying debts as they become due, and so if a creditor is not getting payments, that would give him cause to actually bring this kind of a petition, involuntary petition. Possession and control of the debtor's property has been taken from the debtor within 120 days prior to the filing. So that he's basically losing control of his assets, which are oftentimes maybe pledged and are the source of security, even for unsecured creditors. Even unsecured creditors think that if a person has substantial assets, some of those assets may remain and create surpluses that are therefore available to be claimed by general creditors. So I mentioned the fact that surpluses go to the debtor. There is a possibility in a bankruptcy that general creditors of the bankrupt, we usually call these the debtor, general creditors of the debtor in bankruptcy, may actually apply to get those surplus funds as payment of their debts when they have been paid. So those could be actually also persons who are entitled to payment before the debtor or his sureties. Possession and control of all the debtor's property has been taken from the debtor within 120 days prior to filing. So that's kind of an indication that the person's financial situation has worsened and indicates possible insolvency, right? Automatic stay. The automatic stay is something you get upon filing. So once you file once you make the filing, all creditors have to stop calling you up, sending you notices that you need to pay. So they're not permitted to any communication. So up until you file bankruptcy, they can ask you to repay, right? They can send you letters. They can call you up. There is a certain limit to what they can do. You have a certain privacy rights, so they can't call up your employer and tell him, this guy owes me money. Can you see that he pays me? They can't do that kind of thing. That's an invasion of privacy. Nobody is entitled to know that you are in fact, so they can't have things on the outside of the envelope that's being sent to a house that would indicate other people, or an apartment building, or that would indicate to other people that this person is in debt. And, so the envelopes cannot really indicate when you're sending a dunning letter. We call that a dunning letter, right? You're dunning the person. D-U-N-N-I-N-G. when you send a dunning letter, on the outside of the envelope, it doesn't say something about him owing money. It's just, it just says the person it's from, and the return address, and what the address of the person is, and his name's on it. Okay. Upon the filing of a petition and notice to the creditors, all attempts to collect debts must stop and await the findings and decisions of the court. So you can't send him any letter asking him to pay. He's in bankruptcy. He'll be ordered to pay what he can after the trustee maybe takes possession of his estate. That's determined by his filing. So he will have to give a detailed list of all the assets that he has and what they are, and he will have to state those exemptions that he's claiming and that he's able to claim under the state exemption laws. And so you get a picture of how much money might be generated by putting things up for auction in on the bankruptcy foreclosures. Stay does not apply to alimony and child support, so people can still ask for their alimony and their child support, including paternity debts. So this includes, paternity debts are actually where the persons weren't married. So a person who is has been ordered by a court to pay for a child that he had out of wedlock, his rights are going to be curtailed, and that he'll still maybe be getting debt letters on this, because these are the kinds of debts that are not dischargeable in bankruptcy. You have to pay the law requires you to pay for children that you have produced, whether in marriage or otherwise, and so you remain responsible for that. Usually, however, a lot of times in the past, I don't know if it still works this way, it's left up to the woman. If the woman doesn't pursue the man for the money, and sometimes that has happened. I've had women who said they didn't want to ask him for the money because they didn't want to have anything to do with him. So, and I say, well, you really should, and basically you should for the child's sake, that the child has a father, and therefore that father should be held responsible to pay what he's owed. And to certain criminal proceedings also, for certain crimes you have to pay fines to the government. In other cases you may have to make retribution. For certain criminal proceedings you may be that will not be discharged in bankruptcy. So we're talking about discharges. You don't discharge the alimony, you don't discharge the child support, you don't discharge criminal proceedings. There are certain kinds of even tort suits that are not going to be dischargeable in bankruptcy. Typically the kind of things that might get you into having punitive damages where you've acted maliciously. Adequate protection doctrine. A secured creditor can file for relief from stay in situation where the stay will cause the value of the collateral to materially decline, and either periodic or full payment is necessary to protect the creditor's interest and repayment. And so, he can file for a relief from stay. You can also do that in regard to assets that you believe are going to disappear. If you believe the debtor is hiding assets and is planning on, disposing of them illegally, you can ask for a relief from stay. You can maybe even get a sheriff to go out and attach that property, that is, take possession of the property, or post, if it's real estate, post on the property that this property is subject to bankruptcy. If you think you have reason to believe that the person is that kind of scoundrel, that he's going to do that, and so you need to have some reason to get these extraordinary measures taken. All property at equitable interest. So what assets are taken for distribution, for sale and distribution? All property in equitable interest at the filing, except all property transfers also. So plus you would also get all those that are listed in the filing, certainly, are subject to being available for distribution. And some of these will be claimed as exempt. All property transfers avoided by the trustee. So if indeed you did give your mother-in-law that nice new car at really 10% of what it costs you, and you've only had it for 3 months, Yeah, he's going to avoid that transfer, and she'll have to surrender that car, and he'll be able to sell that car and get what it is. Other than that, you probably could have reaffirmed that debt if that was your only car, and made the payments on it. Of course, you know, it might be nicer to have your mother's name on it, owning it, and drive it and not make any payments at all. But obviously that's an abuse of the Bankruptcy Act. And this was a case that occurred prior to the 2005 bankruptcy relief case that I knew about. I wasn't actually involved in it, it wasn't my client, but I knew the individual who was doing this. So I had some claims against him myself. All exempt property, that's all exempt property. So all property transfers are avoided by the trustee, and all exempt property, you subtract those. So you add the property the trustee has avoided, and you subtract the exempt property. You subtract property on which debt was reaffirmed, because you can't sell that. The debtor will make payments on those according to, usually it's going to be according to the regular schedule. He is going to be relieved of all these other debts, so he'll be able to probably to pay off that mortgage, pay off those 2 cars, so that he and his wife can both go to work. And so that's the kind of thing that you can get reaffirmed. You can't get everything reaffirmed. Like I said, you can't get the DeLorean reaffirmed because it's too valuable a car. There's a limit. There's an exemption for cars. You know, and if a car is actually cheap enough, let's say it's less than $1,500, the car is not worth very much. And it might be exempt under state law. So under state law, it would be maybe exempt, and therefore you don't even have to reaffirm it. You're able to keep it because you don't have a very valuable car. But that would not apply to the DeLorean, would it? All proceeds and property distributed to secured parties. So secured parties, again, it's like the bank with a mortgage. The secured party is probably going to get all the money from the sale of an item that let's say you had an extra car, that DeLorean, you bought it on some sort of payment plan from a dealer, and he had a security interest in it, and so he was able to take it, repossess it, and the bankruptcy trustee, the bankruptcy court will allow him maybe to sell it and take the proceeds. And if there's surplus, maybe not likely, if there is surplus, then maybe that surplus would be paid into the estate. But if generally property distributed to the secured parties for sale, or maybe even for under strict foreclosure where they keep the property. In those cases, those are going to be deducted from that. Once you get through that formula, which is all here in the PowerPoint, you see these are the assets available for distribution. So that's just a simple formula. I'm sure there's a more complicated formula than that in the new bankruptcy forms. Exempt property partial list. A homestead. There's an exemption for homesteads. However, most homesteads exceed the value of those exemptions in most states. So basically, most people are reaffirming their homesteads. But there is an exemption if you have a particularly inexpensive home, you know, single dwelling in a depressed area where there isn't a whole lot of value to the properties. It might qualify for exemption. Vehicle, like I said, I think last time I looked, the low number for the exemptions were like $1,500, which is not much for a car. Furniture and clothing are exempt. So what do you get if you sell people's clothing? Not a whole lot. It's used clothing, except in extraordinary cases where somebody has very valuable celebrity clothing. So if you have an actress or an actor or a baseball player or football player, somebody who has the kind of items that collectors would pay big money to get, those would be not covered by this exemption for the clothing. You know, that exemption doesn't go up that much, so there's a limit to it. So you know, your closet, maybe the clothes you got in your closet, maybe if we were to get a fair price for it, maybe it'd be $100 per closet. Okay, I mean that's maybe generous. And also jewelry. The jewelry would be for a wedding ring. It's a small amount, $150. I think when I last looked at it. I haven't looked at it in years though. So it was basically just to keep a wedding ring. So basically you could apply that, and you could reaffirm that, I guess. And you still owe money on the jewelry. Tools. Tools also. Workers need tools, so if you're in the construction business, you need tools. Health aids, your CPAP machine, your crutches, whatever, your wheelchair, whatever, would be exempt property on the exempt property list. Even a car that's equipped with a lift. Life insurance is exempt. Check for detects for others and limited on each of these. Now I think we're out of time, so I'm not able to go through. There are other things on here. Maybe I can pick it up on the next lecture. But there are also questions at the end of this. So there are 5 practice questions you might want to look at. Thank you very much for this, and hope you do well on the test that's going to be coming, because pretty soon you'll be getting a test which is going to be on Canvas. So I've made arrangements to make sure that happens, and we're working on that now. Thank you.